Good afternoon. Welcome to this episode of Lawyers and Friends. I'm Vicki Buehler. I'm one of the associates with the firm, and with me I have my friend and colleague, Neil Diegelman. And we are going to be talking about the really fun topics of permanent total disability, total industrial disability, and the hardship redetermination. All of which are topics you never want to see on any of your files.
Thanks, Vicki. Let's get into it.
So we're going to start with permanent total disability. We all know what it is. The claimant is permanently totally disabled from doing anything. Now, what you may not know, though, is there actually is a law that controls it, 15.1. And that law actually says that there is a mandatory permanent total disability if a claimant loses both hands, both arms, both feet, both legs, both eyes, or any combination thereof. So basically, if they lose two body parts, they have a claim for permanent total disability. Otherwise, permanent total disability is going to be determined in accordance to the actual facts of the case. And I actually did have this come up on one case, Neil. I had a guy who had a vision problem. He couldn't see out of one eye, and then he had an injury to the other eye, and he was making a claim for perm total, and he got it just by statute.
Right, so it's by operation.
Yeah.
Right, and the other cases are where we're about to get into it, is when it's with accordance with the facts.
Exactly. So a permanent total disability is established where the medical evidence shows that the claimant is totally disabled and can't engage in any kind of gainful employment. The key here is the medical evidence. So in order to determine if a claimant has a permanent total disability, unless they're missing body parts.
Two body parts.
Two body parts, exactly. Can't be one, got to be two. The judge has to look at the evidence and use that evidence to determine if there's enough for a permanent total disability. And really crucially here, that has to be based on the causally related established sites. So, for example, we have a case where there's an underlying unrelated neurological condition. The judge can't use that to find a permanent total. It can only be based on the established conditions.
So, and in that case, there was unrelated conditions, including diabetes, which we've seen before.
Yes.
And I think it's interesting to point out that they apportioned the causally related.
Yeah, exactly. So
total disability.
In our example case here, the board did find that the judge was right in saying this guy had a permanent total disability, but they also said that there was only a 38% causally related disability because the rest of that disability was because of the unrelated conditions, primarily diabetes. He had really bad uncontrolled diabetes from the case law. And so all the awards were only at that causally related 38%. So yes, there was a perm total, but we were only on the hook, the carrier was only on the hook for the 38% that was actually related. So that was actually really interesting and, something to keep in mind. If you're looking at what looks like a possible perm total and somebody's got pretty serious underlying conditions, yeah.
Sounds like we have some ways to defend against this permanent total disability.
Yeah, there are some ways to defend against it. And this is how we can do it. First off, you're going to want to look really closely at that medical opinion. And by that, I mean, don't just go to the bottom and look at the part where he says permanently totally disabled, can't do any work. Go and look at what the claimant's reporting. A lot of doctors will ask, what do you do? What are your daily activities? What do you have problems doing? If they can do things, they're probably not permanently totally disabled. Also look for inconsistencies. If the doctor says, he can't do any work at all, he's permanently totally disabled, and by the way, he has a severity A, which is the lowest you can get, that's an inconsistency. That's a problem. That's something you're going to want to look at and question them on. Similarly, I unfortunately have had IMEs come back and give a permanent total. Again, go look. Any IME should be asking the claimant, what can you do? What are your daily activities? If they're saying this person can walk and, feed themselves and sit down for long periods, that's not going to be a permanent total disability. So you can't just look at the end that says permanent total and go, oh no, we're done, we're screwed. We're not necessarily. So really read the report.
And it's sometimes uncomfortable, of course, when we get an independent medical examination and it is a perm total, and then we are in the position where we need to find and poke the holes in the IME report, and that's kind of uncomfortable. But I mean, when you're facing a permanent total disability, really, like, that's worst case scenario in a permanent disability, and you get total. So you start doing what you got to do, and keep it in mind next time you need to choose an IME doctor.
Yes. Don't use that doctor again. But, as the case we've shown here shows, even if your IME says perm total, that doesn't mean the end of the world. Read the report. If the report's inconsistent, you treat them like a hostile witness, and you basically undermine your own opinion to the judge. It's not fun, but it is doable, and we have done it.
Absolutely.
So worst case scenario happens, the judge comes back and says, yep, this person is permanently, totally disabled. What do we do? First step, look at the decision and see why they did it. You will sometimes get these decisions orally at a hearing, but a lot of times, recently at least, I've seen judges giving reserved decisions. They want it written out because they know somebody's going to appeal. So in that decision or at the hearing, did they say why they don't think the claimant's capable of any kind of work? Bear in mind, perm total means you can't do anything. That is how bad your medical condition is. So what factors are they relying on? How did they reach this determination that they can't do anything at all, especially in today's era of remote work where you can sit and do things a lot of the time?
The travel time doesn't impact your decision.
No. And then, like Neil said, perm total is the worst case scenario. It does not get worse than that. Perm total, as we all know, means that there is no cap on benefits. You are now looking at a lifetime case.
At 100%.
Exactly. This is
total.
This is the worst case. So you have nothing to lose by appealing. The benefit of appeal, you're going up to the board panel. They are going to look at everything again. You're getting a second bite of the apple. Take the second bite of the apple.
Right.
And then also, one other thing to consider, obtain surveillance. So let's say you've got a perm total, you're up on appeal, you're waiting, you're probably looking at 6 months now for a decision?
To come back, about.
At least. Think about getting surveillance. Remember, permanent total means this person is supposedly incapable of doing much of anything. So if you get them doing much of anything, you now may have a really good basis to raise fraud. And fraud lets us, if we can get a lifetime ban, discretionary lifetime ban, that's going to do away with the benefit of the perm total. So definitely something to think about and something that we usually would recommend doing.
Right. And with the surveillance, I think I've seen it as light as the claimant was able to drive, and that was not enough. But the amount and time of driving, they said, well, he could be a driver.
Yeah. I mean, the thing about perm total that claimants don't think about is you are supposed to be really physically screwed up to get it. So if you're caught doing anything, that's a pretty good basis for arguing for fraud and seeing where we get on it. ATF or no ATF? So the workers'
aggregate trust fund.
Aggregate trust fund, yes. The workers' compensation law actually does have a mandatory ATF deposit if someone has a permanent total disability because they lost 2 or more body parts. Otherwise, there's not a mandatory ATF deposit. There may be a discretionary one, but it will not be a mandatory.
And now, why the judges are given the discretion, we didn't get into it. Let me say it that way.
It's up to their discretion, and we can talk about it at that point, but at least it's not a mandatory one, so that's at least something. And then our next issue is total industrial disability. So claimant's attorney argues for perm total. they don't get it. The judge says, nope, they're capable of, say, sedentary work.
Hey, good job.
Right? The next round is probably going to be a total industrial disability. At least in my experience. What do you think?
Absolutely.
Yeah.
Sure. They're taking every swing at the claim that they can.
Yes. So a total industrial disability is different from perm total. Perm total is based mainly on the medical. For a total industrial, we are now looking at everything else. And they're similar in that with a total industrial disability, just like a perm total, you still get the lifetime benefits. That is why claimants' attorneys will say, oh, no perm total, hey, I'm raising total industrial now.
And this is why you'll see it in combination because if they're saying it's a permanent total disability, as we'll get into LWEC, obviously there's 3 factors, medical, vocational, and functional. They're still trying to drive that number up to 99%
Yes.
using the functional and vocational factors that the total industrial dips into. So they, at that point, I'm not saying that they don't have anything to lose, but I mean, like, they're swinging at a total industrial because they also want, in the third alternative, I guess, right?
Yeah.
A 99% LWEC.
I mean, really, they don't have anything to lose at that
Right.
point, so they're going to try for it.
Because the evidence really doesn't change.
Right, exactly. And if you've got severe enough medical evidence to support a claim, at least for a PTD, you at least have a potential argument for a TID.
Right. And I mean, I'm venturing to even say, like, even if you didn't, I've seen it where they're like, well, they're still going for a TID.
Yeah.
It's not plausible. They have a college education or something crazy, right? But
they're still going to try.
Yeah.
Yeah.
We're ready for that when they do it.
Yeah. So what is a total industrial disability? Basically, the claimant is saying they are totally incapable of returning to work, any kind of work, due to their causally related permanent partial disability and then other unrelated factors. So first off, in order to claim a total industrial, they have to have been classified with a PPD. Any kind of PPD could be as low as it goes, can be as high as it goes, but in order to try to claim it, there has to have been a PPD finding. And then you include other factors. So age, education, ability to read, write, speak, usually in English, limited vocational background. So somebody who's done very heavy manual labor all their life and they can't go back to that, they're going to try to throw that in there. And they can throw in unrelated medical conditions. I call it the kitchen sink argument because they're throwing everything to see what sticks.
So that's interesting because here you have the unrelated medical conditions that should be considered. Mm-hmm. When we're dealing with a permanent partial disability, or excuse me, a PTD, I said it wrong, a permanent total disability. Do we care about the unrelated medical conditions?
We don't, because the permanent total explicitly has to be limited to causally related. Here, because they can throw in other unrelated factors, they can try to throw in other unrelated conditions too. I usually see it with more severe stuff like diabetes I've seen before,
COPD.
Cancer, COPD. It's not usually little things, but a claimant's attorney is going to throw it in because the more weight they can add to these other factors, the worse they can make their person seem. Theoretically, the better their odds of getting TID.
I love it when they say, well, the claimant's had 4 surgeries. And you're like, that's wonderful. They should be totally fixed by now. Because anywhere else outside of compensation, they'd be better.
Yes, those are always fun. So again, TID can't come up until the claimant's been classified. And oftentimes you will have the judge say, oh no, I agree, there's no permanent total here, I'm going to find a PPD. And then the next word out of claimant's attorney's mouth is, I'm raising total industrial. Yeah, that happens a lot. They actually don't have to do it that fast though. They usually do, but they don't.
Yeah, I mean, it's while the ball is moving.
Yeah, exactly. But technically speaking, they can actually raise TID at any time. There's no time limit on it. And actually what we found when we were looking into it is it's not uncommon for claimants to argue a TID, if they haven't already, when they're seeking a hardship exemption. We'll get more into the hardship redetermination a little later, but just keep in mind, they can do it at any time. There is not a time limit. They can technically even raise it after they've exhausted the caps, and that was an unpleasant surprise for me to find out.
That is very unpleasant.
And with a total industrial disability, the burden is on the claimant to prove they're incapable of gainful employment. And when I say gainful, I mean any kind of employment. The board has made it very, very clear that they can't limit themselves to their educational, field. They can't limit themselves to prior experience. It has to be any kind of work at all. Otherwise, you don't qualify. And in order to do that, they have to provide sufficient evidence that he or she is functionally incapable of working due to both the causally related conditions and then everything that's unrelated, so all those extra factors. So it all comes into play here, but they can't just say they're not doing it. They actually do have to provide some evidence, which is a saving grace when it comes to TID, I think.
I do too, and I think part of it that maybe as a litigator I'm not necessarily used to seeing all the time, because you don't see TID all the time, but when you do, the evidence that's needed for these unrelated injuries and conditions, absolutely we
Yes.
don't take for granted that the claimant has diabetes. Prove it.
Yes.
You have cancer? I'm sorry. Prove it. You have the COPD? That stinks. Prove it. And that way it prevents the I said I have it. I told a doctor right at the beginning. We're getting right down to it. So that might produce additional legwork, additional provider lists, HIPAA requests, and then the process thereafter of then securing the records through the subpoenas and the HIPAAs that we have. So
Yes.
It's just something to keep in mind because usually we don't care about these unrelated conditions.
And that's a great point.
At this juncture.
Yeah, usually we don't.
Right.
I mean, it really usually doesn't affect us that much at this point, but Neil's absolutely right. That's a great point. And also keep in mind too, like Neil was saying, burden's on the claimant. So if we're asking for this and they're trying to rely on it, they have to produce it. They can't say, oh, well, we don't want to do that. Too bad. You brought it up. You're relying on it. You have to prove you're incapable of employment. If you're going to argue all this stuff, you got to prove it to us.
And be ready to answer some questions.
Be ready to answer a lot of questions. And not very nice ones at that. So, for example, there was a pretty recent case back in March where the claimant claimed total industrial disability. This was a pretty messy case. He had established cardiac arrhythmia. He'd had a whole bunch of surgeries resulting out of that. He had actually an internal pacemaker planted in him. And so the judge said, okay, 75% PPD. Per the VDF-1, he had spent 75 years working as a smelter, which... 37, sorry. Working as a smelter, which is pretty physical as far as I'm aware.
Right.
He'd only done physical or manual labor work, so it's not like he had any kind of experience with what I would usually consider to be a sit-down type job.
Right. Reading, writing, computer use.
Exactly. He could read and speak English. He actually couldn't write very well. And he had very limited computer knowledge. So he actually did do a job search for sedentary work. Unsurprisingly, didn't find anything. And the board panel said, no, this is not enough for a total industrial because he was proficient in English. He could lift 15 to 20 pounds, which sounds about sedentary. And he was capable of sedentary work per the judge's PPD findings. So that was enough. He was capable of working. He was not totally industrially disabled. They didn't care about the rest of it.
Right.
So it is a pretty high standard to reach. I mean, it's sort of like PTD in that. It's not an easy thing. You can't just claim it and get it.
Right. That's good.
Yeah, very good.
Yeah.
And then in a similar case, we had a 71-year-old claimant. She had a claim for back, both knees, and this was interesting, consequential depression. So she was throwing psych in there. It's never fun when they throw psych in there. She had a high school education, and she actually had experience as a cashier and a sales clerk. Her doctor said sedentary work. The judge classed her with sedentary. Claimant's counsel came back and said, look, she's 71. She has a high school diploma. She's completely computer illiterate, and she can't go back to her former employment. And the judge said, no, that's not enough. Yes, I get that she's got these permanent restrictions. She's got vocational restrictions here, but she can still work. She still has a residual earning capacity. So again, this is a high bar. I mean, the age didn't matter here. The computer literacy didn't matter. This is still a pretty high standard, which we are very grateful for.
And the residual earning capacity, we'll see it throughout some other decisions. But I find that interesting because it dovetails with what you're saying. The standard is so high that, like, they're not saying what.
They're not.
They're saying that the term of art, the residual earning capacity.
Yeah, and actually that's a really good point. Like, when they say total industrial disability, they actually mean that.
Right.
Like, they're not saying, oh, you have 75% loss of wage earning capacity, you can only do certain things. They don't care. If you can do anything at all, that, in theory at least, is enough to defeat a total industrial. And the case law I went through actually did support that. Mm-hmm. If you had any kind of residual earning, no matter how teeny tiny it was, you were not totally industrially disabled. So that's actually a really good thing.
Absolutely.
And that's certainly something we would want to hit on if this comes up.
Mm-hmm.
So evidence needed for total industrial. Remember, the claimant has to produce this first because it's their burden. So we should absolutely be requiring them to produce job search evidence showing their efforts to work. Again, that is not limited to any field. It's not limited to any experience. I don't care if you have a degree as, a geologist, for example, and that's all you've ever done. Doesn't matter to me. It's not limited. You can't limit your job search to that. They also have to provide medical evidence saying the claimant is functionally incapable of working. So if, for example, you have a permanency opinion and your doctor said, hey, you can do sedentary work, well, congratulations. You got to produce evidence now that says you're functionally incapable of working. And then another thing they can do, and I have rarely seen this, but they can produce a report from a vocational rehabilitation counselor. Claimants, that's usually Access VR, and they're usually a little reluctant to do this. But theoretically, they can produce a vocational rehab report saying they're completely unsuited to do any kind of work. If that happens, then honestly, what we might want to do is get our own vocational rehabilitation report, because I don't know about you, if you've dealt with them before. I've had a few.
Yeah.
And our counselors are usually pretty good at finding something they can do.
Well, not even something that they can do. They're more, in our experiences, they're more thorough.
Yes.
They're provided with more information, because at this point, if we're deciding to go with the voc rehab counselor that we want to send the claimant to, we're asking for stuff from the assured or the employer. We're asking for that job description,
Yes.
that injury job description. We're asking for other types of jobs that are available at that employer to see maybe there's something there that the injured worker could fit back into. Rarely have I seen it go the other way, where the functional capacity evaluation from claimant's own choosing actually includes the specific details that I had just alluded to. So that is certainly a way that we can that we do combat the FCEs when they come back, or the voc rehab when they come back, and it's not favorable, but there's something there's hope.
Yes, there is. Yeah, and even the FCEs, those are really more of what they can do.
Yeah.
And I feel like we could even argue that in and of itself isn't a voc rehab, because it's just what they can do.
See?
These are not necessarily people who are trained counselors in
Right.
this field. So again, you have defenses, and we're more than happy to argue those defenses. And so, of course, you want to go through the evidence that the claimant has produced, look at the job search, and, the job search has to be like any other job search. They got
American Axle.
Exactly. I love American Axle. Resume. Emails confirming that you actually did apply, the types of jobs they applied for. All of it has to be documented, American Axle. If that's not there, that should be a very significant blow against any TID claim.
Timely, diligent, persistent.
Yes. And then also, if they do have a vocational rehabilitation counselor report, review it. Like we said, consider getting our own. And then, of course, you always want to take claimant testimony. Oh, yeah. You never know what they're going to say. And that would be on issues including work experience, language proficiency, education, functional limitations. What can they do? What can't they do? I don't always trust what doctors say, because claimants tend to say they can do less or more. Their training, that would include specialized training, work experience, certifications, all that fun stuff. And then, of course, their work search. Work search is always fun to take claimant testimony on.
Don't you think it would be fun at this juncture, if you're doing this avenue of, TID, that you would get the digital recording minutes from when it was the PPD trial?
Oh, absolutely.
Right? And absolutely line those up and make sure that the claimant at first and or second told us everything about his work experience, language proficiency, educational functional limitations. Because I tell you what, one of those are inconsistent. We got some other things going on that we're going to dive into.
Absolutely, we do. Yes.
Right.
Always want to look at those. And
so while it seems intimidating, it's really not.
Yeah. And, finally, we argue that there is some residual work capacity, because if you have any residual work capacity, that should be enough to defeat the total industrial.
Well, there's those words again.
I know. And, always, go ahead, next slide. And before we get into this, again, with the total industrial, I would say too, appeal. You're looking at the worst case scenario. You're looking at lifetime benefits.
The functional outcome is a PTD.
Exactly. You're dealing with a judge who's had to listen to the claimant whining extensively and may feel sympathetic, and the board panel decision may have a very different take on it. They're fairly draconian when it comes to this stuff. So, again, always worth an appeal if we lose. Back. And last but not least, extreme hardship redetermination. So perm total is all about the medical. Total industrial is all about mainly everything else and some medical. Extreme hardship is all about the money. So the 2007 reforms, like we all know and actually do like, limited the PPD claims to a set number of weeks. They put a cap on how long a claimant could be out of work. That is hugely important, because before that they could theoretically be out for eternity, and lots of them are. And that number of weeks is determined by the amount of the PPD. However, they then backtracked and put in a safety net. And that is Workers' Compensation Law, Section 35.3, the extreme hardship redetermination. What that is that allows the board to reclassify a claimant to a permanent total disability or a permanent industrial disability due to factors that reflect extreme financial hardship. I have absolutely no idea how the judge picks which one they want, but since the outcome's about the same, I don't think it really matters.
I don't think it matters.
Yeah, I think they can just pick whatever.
I bet you the legislature put both in, because who wouldn't make the argument that, oh, well, we still got the other one, either right. Permanent total or the TID.
Yeah.
So the permanent
And in regards to that, I mean, like, it's kind of funny too that they backtracked. I mean, like, the whole point of those initial reforms was to put limits.
Right.
I mean, at least on the carrier side, to put limits on the number of weeks, like to limit our liability. And then they were like, oh, wait a minute, we reconsidered. We're going to put a safety net in here just in case.
Right.
Make it a little difficult, but still safety net. Here you go.
And it is difficult, and it is distinct. Well, it's just different than what we've been discussing.
Yeah.
So it almost opened up a new avenue once the reform came through in 2007.
It really did, actually, because until that point, I mean, I can't think of anything where we actually considered financial hardship before.
Right.
Or even the claimant's finances, to be honest. I mean, it really didn't matter.
I don't remember it, yeah.
Yeah, I can't think of anything. So there are some limits, thankfully, to the hardship exception. First and foremost, it only applies to claimants with a 76% or higher LWEC, which is why you always want to try to get claimants at 75% or lower. 75% or lower, they can't make this claim. Doesn't matter how bad they think they are, they can't do it. And that is also why you will sometimes have, when you're hovering around the 75% range, sometimes, at least in my experience, claimants counsel will be like, oh, can we do like a 76? No.
Right.
This is why they want it. Don't do it.
This is exactly why they want it.
Yes, exactly why they want it.
They don't want that 1% payment.
No, they want this. It has to be asked for within the year before the caps are set to run. So, you get somebody classified. This is not something that is going to come up right away. This is something that you're going to have to be keeping an eye out for the year that the caps are set to run. They can't do it before then. They can't do it after then. They have basically that 12-month window. That is it. So either they do it or they're completely out of luck. They can do it anytime within that year the caps are set to run. So keep that in mind. Sometimes you'll have them do it early if they have their act together. Most of the time it seems like a frantic flurry. And
Oh, absolutely.
About when it's supposed to run.
There's about 3 months left.
Yes, exactly. That's usually time for
There's about
resting.
7 RFA ones in the file.
Yes. And in order to make the request, they have to file the completed request for redetermination within the year the benefits expire. And we're getting into what that involves in a second here, but like it has to be fully done. They're not supposed to submit like half fill that one and then start adding financial information after that.
Right, it can't be used as a placeholder.
Exactly. So that's something to keep in mind. You actually will see that happen because you do see claimants file within like the last 3 months.
Yeah,
And then
you'll see more filed in the board file, and you just make the argument that's not how it works.
Exactly.
How does it work?
How does it work? So basically, the claimant has to submit a completed form along with financial information, and they got to submit a lot of financial information. They're trying to argue they have an extreme financial hardship. They have to prove it. And they have to prove it by showing us everything.
Show me the documents.
Right? So, household income. That isn't just their income. That includes the income of a spouse and anybody else living with them in that household. That includes pension, Social Security, retirement, monthly expenses for housing, credit cards, living expenses, transportation, student loans, food, personal care, utility, taxes, child support payments. Everything has to be included. So when we say it has to be complete, we mean they have to submit a complete, detailed financial record if they're going to try to claim they have an extreme financial hardship, which makes sense because that's what we're going to use to figure out if they do or not.
You'll usually see the evidence that's being produced in the form of like a credit card or a bank statement.
Yes.
But I think it's important to remember that not everybody uses credit cards or bank statements. And I believe there's at least one case that I recall reading when I had a recent redetermination case. But the point was that they used cash for everything, so that they were just saying their house expenses were X, their food was Y, gas was another. And I believe the board panel came back and basically was like, well, you could have produced receipts. Like if you're not using your card, where's the receipts? And there were a few other cases out there where it's just, you say you have student loans, but they failed to produce the documents. And in one case I had, the judge directed it then at the next hearing, it's not produced. I'm throwing a fit that it's not produced. Not that they didn't produce it. that was their chance and they didn't produce it. So there's no evidence, and that piece of their application is out the door. We don't want the judge to consider the student loans, the personal care, the housing, your utilities, because you didn't provide any evidence beyond saying I have these obligations and debt. I think from a perspective, like sometimes it seems a little petty or nitpicking, but I mean the nitpicking, the win is in the details.
Yeah, it is. And if they're the ones trying to make this claim, then it's on them to prove it.
Make it uncomfortable in a sense, not on purpose, but make them prove the claim.
If they want to make the claim, they have to prove it. And I agree, that has to include some kind of documentation. You can't take their word for it.
Right.
Claimant's lie. We all know this. Next. So there's a whole bunch of cases out there, but here's a good example of one where they found that the claimant didn't qualify for extreme hardship. The judge had actually found extreme hardship because the claimant had a high enough income that he couldn't get government assistance. The board panel said no. The board panel said actually if his income's high enough that he doesn't qualify for government assistance, clearly he cannot have an extreme financial hardship. He doesn't qualify. And the court agreed. The court said that there was substantial evidence that supported the board's determination that the claimant had failed to demonstrate any unusual or unexpected expenses for someone on a fixed income that would rise to the level of extreme hardship. You see that language all the time in these decisions. Like every single time it comes up, one of the things they look at is were there any unusual or unexpected expenses that would meet the threshold of extreme hardship. So the board is not defining extreme hardship as your income is less than what you're paying out.
Correct.
At all.
Right.
Like they're actually saying, no, that's not the case. It has to be rise to the level of extreme. And so, for example, here's a case where a claimant did actually qualify for extreme hardship. And that was on the grounds that, or no, sorry, the judge found the claimant qualified for extreme hardship because the claimant lived in a really remote area, which living upstate New York, I can tell you, it was in fact a really remote area. He had to use a mobility cart when he went around, and he had to pay his family for help to do laundry and chores around the house. Board panel came back and said, nope, he has discretionary expenses because he can afford to pay all these people to do things for him. And, oh yeah, he's making charitable donations. If he can afford to do that, he does not have an extreme financial hardship. So again, you really, really, really need to look at the nitty-gritty details of this stuff, because this one was, in a lot of ways, yeah, like they really focused on, in the decision a lot on like the charitable donations. They were almost offended that he's donating to charity and then trying to claim he had an extreme financial hardship. So you need the documentation, you need to review it, and like Neil said, nitty-gritty is what wins these. And then there is actually a case where the board actually did find extreme hardship. It was pretty extreme. The claimant had an 87.5% loss of wage earning capacity, and he actually was making a net of $24 from Social Security. He hadn't worked for 11 years. He had a high school diploma. He had been a manual laborer. He had a history of basically really heavy-duty like construction type work. He was actively looking for work within his restrictions. Access VR, so there's your vocational report, said they couldn't help him given his restrictions, and he got $15 a month in food stamps. His expenses were fairly high, about $2,174 per month, so certainly much, much, much more than he was bringing in. And the board panel said that without the work comp benefits, his income would solely consist of his fiance's monthly SSD benefits. So again, they did look at the income of the other person's household, in this case his fiance. They factored that into their determination. And then they said, okay, look, you know, he has all these restrictions. He really doesn't have a high level of education. His job skills are no longer applicable here. He can't do it. He can't go do the prior job. VESID can't help him, so he can't get reemployment assistance here. And all of that combined provided very significant restrictions to his ability to find a job or to bring in additional income. He was on multiple forms of assistance, which they noted. He was on SSD, food stamps, and the reduced rent. And even with that, he was still making like $24 a month from Social Security. So they said, all right, look, this is clearly a extreme financial hardship. And again, they went back to the same language. They said this is beyond what could be considered ordinary for somebody on a fixed income. So this is an example of extreme, and this is apparently the level they're going to go to.
Right, yeah.
I found one other case where they did uphold an extreme hardship. That person made $16 a month. So when they say extreme, they apparently mean extreme.
That is absolutely...
And, you know, when we say that they are saying that it has to be above and beyond what somebody living on fixed income is, Neil can talk about that because he had a fun case.
Oh, sure did. I had a recent case where I was defending a extreme hardship redetermination, and the claimant had produced the documentation evidence. There was no issues per se there. But specifically, the claimant had sold his house to his daughter for a reduced amount, about $40,000 less than what it would have been sold for.
That was convenient.
He took the profits from the sale of the house and purchased a truck and a fifth wheel, a recreational vehicle, and had that for a short period of time, and that was too small for him and his wife. So I don't know how you return something like that, but he returned them and got a larger truck and a larger fifth wheel RV, and was using that as their home. They would park it in some places in upstate New York with fees associated with it. They would drive down to Georgia and then decided to go on a year-long trip across the United States in their RV.
Well, that sounds like a fun road trip. I want to do that.
I would definitely, a year long.
Right?
during the testimony, it became clear that that was always the plan. So when the claimant, I pointed out in my summations and on appeal, that while the claimant testified that the decision to sell the house was to save money, so he didn't have costs associated with upkeep and whatnot, that the decision was at least in part, if not wholly, motivated by a recreational desire, i.e., to travel across the United States in a recreational vehicle with him and his wife that they had planned to do forever. I'm not saying that's not cute. I'm just saying you can't do that on a worker compensation dime,
right?
And then claim that you have extreme financial hardship. What really carried the day throughout it really is the financials. During the course of the litigation, we had the claimant produce evidence. I forget how many years total, but it was at least 3 years prior to him making the hardship application, and the proof is in the facts. I was able to dig out that their fuel cost one year was, I don't know, $1,000. Obviously, that's ridiculous. But then the year that they went on the RV trip, it was $5,000, and I was able to show that their food costs 2 years before the RV trip was like $1,000, and then lo and behold, on the year that they went on the trip, it was significantly more. Everything was more. Car repairs were more. Maintenance was more. Gasoline was more. I wanted to make sure that I was hitting the points. What's discretionary, you can find throughout case law and make your own personal determinations, I suppose. But for me, we got out through testimony his Amazon subscription. He has an internet security monthly subscription, a Netflix monthly subscription, a other streaming service, XM radio subscription service, some GPS service. And seemingly the claimant was happy to be telling us this because he's telling us how he uses it, and it's necessary for him to drive around. Well, the board panel certainly did not, well, I shouldn't say certainly, the board panel did not agree with the claimant or the judge, because the judge found that the claimant had met the threshold.
Yeah.
And the board panel came back and directly pointed out that the decision to sell the house at a reduced price to his daughter was in part driven by the urge to save money on the cost associated with owning a home, but certainly was at least in part motivated by the urge to do the recreational activity.
Yeah.
Therefore, it was not extreme hardship. They went over a few other items in details, but it was not $24. I can tell you that. It was not even close to $24. And so, that was an interesting case where, for what it's worth, the claimant legitimately was like, I'm going to be hard off. And I'm not saying he wouldn't, unfortunately, but I pointed out that he didn't consider that maybe going on the year-long RV trip wasn't the best decision.
Yeah. It's not the best use of your windfall from selling your house at a reduced rate, no less. Did he ever explain why?
No, he did not ever explain why. And the board panel noted it, but never really harped on it. But clearly $40,000 discount that's $40,000.
That's a lot of money.
It's probably another half of a truck.
Yeah, at least. And in that particular case, did they look at all or talk at all about why, the income, how his income, even though it was less than what his expenses were? Did they get into any of that?
Sure. So they went into, I see what you're saying is how they didn't give I think what you're maybe looking for is a dollar amount.
Yeah.
I don't think in this case, they did not delineate it, nor do I think they're going to. I don't think they're going to really delineate what is extreme hardship. It is absolutely a case-by-case situation. I would say if the claimant didn't travel and expenses just increased because things have increased, right? Yeah. And that was part of their argument too, and albeit I get that. But if he didn't travel, I would imagine it would have went the other way. I really do.
I don't know, though, because even then, the board has consistently said that it has to be beyond what's reasonable and ordinary for someone living on a fixed income. So I think you'd still even then have an argument.
There's there are no unusual circumstances in there.
Inflation is what it is.
Everybody experiences inflation.
It's not unusual. It's
you sold your
the
home.
amount's not predictable, but the fact that it's going to happen
is. Sure.
So I still think you'd have a pretty good argument there.
Well, it made it easier.
Yeah, sounds like it. So what do we do if the claimant raises extreme hardship? Obviously, go through their financial records with a fine-tooth comb. Look for any unusual or unexpected expenses, because that really, I think, is what this should be hinging on. I mean, that's what the board panel focuses on. Look for discretionary expenses. Like Neil said, Netflix, GPS, that's a new one. But GPS, didn't they have a phone?
They did, and internet with the phone. I don't know.
So obviously that's really discretionary there.
Right.
Multiple car payments, you only really need one car.
Let me jump in real quick. Just and like with the car payments, also car repairs and stuff.
Yes.
My case, not only did the cost of maintenance and repairs go up, but then when I asked about specifics costs, lo and behold, he's buying tires for his daughter. He's getting his son's engine repaired. So, when I looked at it, I was like, okay, he got tires on that date. That's an auto repair shop.
Yep.
Still went through and asked the questions, and not for nothing. I was like, okay.
Yeah.
Did not know that. Thank you.
That's very generous of him,
Right.
but that really doesn't support his position
No.
that he has extreme financial hardship
Right.
here.
If it was legit, I could imagine a person wouldn't be doing that, unfortunately.
Yeah.
Right.
Really discretionary. And like Neil said, something that you may not realize is discretionary. Take the claimant's testimony, ask them about it, because you never know what they're going to say, and
Right.
it can be really, really helpful. And again, the standard here is absolutely not that the expenses exceed income. Claimants' counsels can argue it is, but that is not the standard. The board has been repeatedly, consistently, very explicitly clear on that. The standard is extreme financial hardship. They have to demonstrate that. So always argue that they haven't met those requirements. And like Neil said, if the judge finds an extreme hardship determination anyway, appeal.
Because that is worst case scenario.
It is. And the board panel is not necessarily going to be as sympathetic.
Right. And recall now the effect of the extreme hardship has the implications of a permanent total
Yes.
disability and or a total industrial disability.
Either way, you are stuck with another lifetime claim. You do not want that.
At 100%.
Exactly. Appeal. It's absolutely worth the effort.
Great.
Thank you for joining us. Any questions?
We do have a question, it
We
looks
do.
like.
Well, I don't know, Brian. I'd have to see what the financials were, but probably not. Any other questions?
Great. Well, this has been great. I'm
It
glad
has.
that we got to sit down and talk about,
Me too.
can't say our favorite topic, but certainly I don't mind litigating it at all.
I don't either. I mean,
It's a good fight.
They're so extreme that
Right.
it is a good fight and it's worth fighting.
And it's worth fighting, absolutely.
Yeah.
Well, thank you again for joining us.
Thank you for joining us. Thank you for taking the time. And if you have questions or concerns, feel free to contact us.